they gonna be your trials? Where's she going?
Are we talking about
The 1,100 cases?
Oh, yeah, yeah.
You will?
I'm not, well, I'm in the office.
I thought maybe they'd grab everybody in the office.
Scan some stuff, but I will be in the trials, so I'm sure I'll take
Wait.
Yeah, there will be a
They'll
lot.
probably all sound the same.
Yeah. And my friend is defending. Thank you. You'll still see me. You're part of the family.
You want to miss up?
Right.
That's true. What? What fool?
And they're pushing him hard. You never know. Things may resolve. I can't imagine it will, but. Oh, yeah.
Oh, no. I've already told him. I already told him.
Good morning, everyone. I'd like to hereby call to order the Escambia County Planning Board rezoning meeting for January 4th, 2022. We do have 4 voting members, so we do have a quorum. And also welcome again to Mr. Kevin Adams. We'll be swearing him in as an official member of the board in just a few minutes, but welcome. I'd also like to thank my counterpart here for taking over the meeting when I had to leave last time. I know there was a lot on the agenda, but I had a meeting that I couldn't miss. When you have a meeting at the governor's office, they don't like it if you miss that. So, all right, here we go. We are called to order. Please turn off your electronic devices, and at this time I'll ask you to stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, thank you. Good morning, staff members. Do we have proof of publication of our meeting?
Yes, sir.
Okay. At this time, we are going to ask our staff members to please read the oath and swear in Mr. Kevin Adams.
Do you, Kevin Adams, solemnly swear or affirm that you will support, protect, and defend the Constitution and the government of the United States and of the state of Florida, and that you are duly qualified to hold office under the Constitution of the state, and that you will faithfully perform the duties as an Escambia County Planning Board member, so help you God? I do. Thank you.
All right, welcome. Got to be careful what you ask for around here. Okay, back to proof of publication. You said we had proof of the publication. Does that publication meet all of the legal requirements?
Yes, sir.
Okay, Chair will entertain a motion to waive the reading of the legal.
So moved.
Motion?
Second.
Second. All those in favor, say aye. Aye. Opposed? Motion carries. The rezoning meeting minutes from the previous board meeting have been provided to the board members. Are there any additions, deletions, or corrections? Hearing none, Chair will entertain a motion to accept.
So moved.
Motion, do we have a second?
Second.
All those in favor, say aye. Aye. Opposed? Motion carries. The rezoning hearing package for January 4th with the findings of facts has been provided to all the board members. The Chair will entertain a motion to accept that rezoning hearing package, the findings of facts, and the legal advertisement into evidence. Do we have a motion? Motion, do we have a second?
Second.
All those in favor, say aye.
Aye.
Aye. Opposed? Motion carries. This time, I'll ask Dave, our court reporter, to swear in the members of the staff that'll be testifying today.
Raise your right hands. Do you solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God? And so you do affirm. Do affirm.
All right, thank you, sir. Board, you've previously qualified all these employees to offer expert testimony in the area of land use and planning. Do any of you have any questions regarding their ability to offer that expert testimony or their qualifications? All right, hearing none, Chair will recognize these staff members as experts in the area of land use and planning. At this hearing, the Planning Board is acting under its authority to hear and make recommendations to the Board of County Commissioners on rezoning applications. These hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings in a court of law, however, it is less formal. All testimony will be given under oath, and anyone testifying before the Planning Board may be subject to cross-examination. All documents and exhibits that the Planning Board considers will be entered into evidence and made part of the record. Opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. Before making a decision, the Planning Board will consider the relevant testimony, the exhibits entered into evidence, and the applicable laws. Each individual who wishes to address the Planning Board must complete a speaker request form located at the back of the chambers. You will not be allowed to speak unless we have received a completed form. Please also note that only those individuals who are present and give testimony on the record at this hearing will be allowed to speak at the subsequent hearing before the Board of County Commissioners. No new evidence can be presented at the BCC meeting. Therefore, all testimony and evidence must be entered into evidence today. The Planning Board will provide a recommendation for each rezoning request to the BCC. They will then review the testimony, documents, exhibits, and consider the closing arguments. They will make a final decision. All decisions by the BCC are final. Anyone who wishes to seek judicial review of that decision must do so in a court of competent jurisdiction within 30 days of the date that the BCC either approves or rejects the recommended order of the Planning Board. All written or oral communications outside of this hearing with members of the Planning Board are considered ex parte communications. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in BCC Resolution 96-13. As each case is heard, the Chair will ask any board member that has been involved in any ex parte communication, please identify themselves and describe the communication. On to the rezoning criteria. As required by Section 2-7.2 of the Escambia County Land Development Code, the Planning Board's recommendation to the Board of County Commissioners shall include consideration of the following approval conditions. These approval conditions show that the applicant has the burden of presenting competent, substantial evidence to the reviewing board, establishing that the requested district would contribute to or result in logically and orderly development pattern. The appropriate surrounding area which uses and conditions must be considered may vary with those uses and conditions and is not necessarily the same area that is required for the mailed notifications. Excuse me. A logical and orderly pattern shall require demonstration of each of the following conditions. Consistent with the comprehensive plan. The proposed rezoning is consistent with the future land use category as described in LDC Chapter 3 and with all applicable goals, objectives, and policies of that comprehensive plan. If the rezoning is required to properly enact a proposed FLU amendment, it must be transmitted to a state agency for review. The proposed zoning is consistent with the proposed FLU and conditional to its adoption. Consistent with zoning district provisions. The proposed zoning is consistent with the purpose and intent and with any other zoning established provisions prescribed by the proposed district in the chapter. Compatible with surroundings. All of the permitted uses of the proposed zoning, not just those that are anticipated by the applicant, are compatible as defined in Chapter 6 with the surrounding uses. The use of any surrounding undeveloped land shall be considered the permitted uses of the applicable district. Compatibility is not considered with potential conditional uses or with any non-conforming or unapproved uses. Also, in establishing the compatibility of a residential use, there is no additional burden to demonstrate the capability of specific residents or activities that are currently protected under fair housing laws. Appropriate of spot zoning, where the proposed zoning would establish or reinforce a condition of spot zoning as defined in Chapter 6, the isolated district would nevertheless be transitional in character between the adjoining districts, or the differences with those districts would be minor or sufficiently limited. To the extent these mitigated characteristics or conditions demonstrate an appropriate site-specific balance of interest between the isolated district and the adjoining lands. Appropriate with changed or changing condition. If the land use or development conditions within the area surrounding the property of the rezoning have changed, the changes are to such a degree and character that it's in the public's interest to allow new uses, densities, or intensities in the area through the rezoning, and permitted uses of the proposed district are appropriate and not premature for the area or likely to contribute to sprawl. At the beginning of each case, as long as there are no objections from the applicant, we'll allow the staff to briefly present location, zoning maps, and photography of the property. Then we'll hear from the applicant, their witnesses. Then we'll hear from the staff and any witnesses they may have. Finally, we'll hear from members of the public that have completed a speaker request form. We have 2 cases this morning, and we will jump right into our first case. First case is case Z 2022-02, being presented by Buddy Page, who is the agent for the owner. 6030 West 9 Mile Road, 2.89 plus minus acres from LDR low density residential to commercial. And at this time, I'll ask the board members, has there been any ex parte communication with you, the applicants, agents, attorneys, witnesses, fellow planning board members, or anyone from the public prior to this hearing? Also disclose if you have visited the subject property. Disclose if you're a relative or business associate of any of the parties. And at this time, good morning, Kevin.
No to all with one exception. I have a school right across there. I live on Frank Reeder Road, and I pass the property almost every day.
All right, thank you, sir.
No to all.
No to all.
Chairman, no to all.
No to all.
All right, thank you. Mr. Page, do you have any objection to the staff presenting the maps and photography? He's indicated he does not, so we'll have the staff. Allison?
Good morning, board members. Allison Lindsay, Urban Planner Development Services. So this is the rezoning case for 6030 West 9 Mile Road. This is the location map showing the location on 9 Mile Road. This is the future land use map showing the mixed-use suburban. And this is the 500-foot radius map showing the current LDR and the commercial zonings next to and near the area. This is the existing land use map. And this is the aerial map of the site. This is our public hearing sign that's posted on the site. And this is looking at the front of the property on 9 Mile Road. This is just another view of the site from the driveway area. This is the property to the east of the subject site that's already under construction for a commercial development. This is looking southeast from the subject site. This is looking south from the property across 9 Mile Road. And this is looking west from the property on 9 Mile. And that's the maps and photography.
Okay, thank you. Allison, just a quick question. The development that's going in next door to this property, do we know what that is?
I believe it's a self-storage.
Okay, all right. Sounds good. Board members, any questions of staff before we bring up the applicant?
Mr. Chair, I have one.
Okay, yes, sir.
I'm sure we're gonna have sidewalks involved in this since it's right next to the school.
That'll be at the development review stage, but
But we don't, that will come when we review it.
Horace, if you would just introduce yourself first, please.
Yes, so Horace Jones, the Director for Development Service Department. As Allison stated correctly, we will review that according to the Land Development Code at the time. And I don't want to misspeak, but I think with that in close proximity, I think the Land Development Code does. But again, I don't want to say anything that's not accurate because I don't have the full knowledge on that. But it definitely will be reviewed at the site plan review.
The reason I asked that is because we had several new construction there and no sidewalks.
I understand? I
Yeah,
understand.
right across the road from the school, so, yeah.
I do understand.
Okay.
But again, if it's required, we will review it definitely.
Yeah, I'll follow up with Commissioner Bagash.
Yes.
Okay, thank you. Any other questions? All right, Mr. Page, if you'll come forward, sir. Sir, if you'll please be sworn in and then state your name and address for the record.
solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, so help you God.
I do. Thank you.
Name and address, please, sir.
Thank you, Mr. Chairman. Buddy Page, 5337 Hamilton Lane in Pace, Florida.
Thank you, Mr. Page. Have you received a copy of the rezoning hearing and the findings of facts?
I have.
And do you understand that you have the burden to providing substantial competent evidence that the proposed rezoning is consistent with the comp plan, furthers the goals, objectives, and policies of that plan, and is not in conflict with the Land Development Code?
I do.
Thank you, sir. Please proceed.
Mr. Chairman, I think first I would inquire, are there any speakers that have been signed up for this?
We do not have any speakers signed up yet.
Well, Mr. Chairman, if that's the case, I would offer to adopt the findings of staff as our own.
Okay.
I have no witnesses, but I would like to volunteer too that the giant oak tree, I don't know if you can see it in the overhead, that will be undisturbed. They have developed their site plan so that it preserves that real large tree.
Okay. Thank you. Let me just ask, is there anyone from the public that is going to wish to speak on this case, Z 2022-02? All right, hearing none, we'll close public comment portion. The applicant has indicated that he'll accept the staff's findings of fact. In this case, we sometimes use an expedited format if everything is consistent. So Allison, if you want to just give testimony about the consistency of the categories, and we can move forward.
Okay, yes, sir. So on all these, all the criteria, the request to go from low-density residential to commercial, it did meet all the criteria for the comp plan, the land development code, and the even the spot zoning, because there is commercial right next door, and there is a traffic generator. So it does meet all the requirements of the rezoning criteria to be, for their request.
Okay. Board members, any questions of the applicant or staff? It's indicated it meets all of the criteria for the rezoning. All right, hearing none, Chair will entertain a motion.
Move to approve.
Second.
Motion and a second. Any further discussion? All those in favor say aye. Aye. Opposed? Motion carries. Good luck, sir. Thank you.
Thank you, Board.
Thank you thank the developer for that tree.
Yes.
I really do. I know it's a pain, and it sounds silly, but that's
Make
great.
a lot of people happy keeping that tree.
Yep.
That's good. Sir? Good morning, Drew.
Before we move on,
Drew Homer, Escambia County Development Services. Mr. Adams, sidewalks are required in the front, along the frontage. If anything, coming in that over 50% of the property is within a 2-mile radius of the front door of the school. So it will,
Got some that slid by on me.
that one will, this one will definitely comply.
I'm gonna give a list to Chairman Pagano.
Cool.
Okay, thank you. Okay, we'll now go on to our next case, which is case Z 2021-09, being presented this morning by Meredith Bush. Congratulations. This is 11355 Lillian Highway, 7.71 plus minus acres from low-density residential to low-density mixed use. And members of the board, on this case, has there been any ex parte communication with you, the applicant, agents, attorneys, witnesses, or anyone from the general public? Have you visited the subject property and also disclosed if you're a relative or business associate of any of the parties? Mr. Adams?
Note at all.
Thank you.
Not all.
No to all.
All right, Chairman, no to all?
No to all.
All right. Staff was notice of the hearing sent to all interested parties?
Yes, sir.
Okay, and was it also posted correctly on the subject property?
Yes, sir.
All right. Meredith, if there's no objection, the staff will present the maps and photography. All right, she's indicated that's okay. So go ahead.
Okay. Again, Allison Lindsay, Development Services. Z 2021-09, this is the location map showing the site. This is the future land use map showing the future land use of mixed-use suburban and the surrounding mixed-use urban. This is the 500-foot radius zoning map showing the current LDR and the adjoining HCLI in the area. This is the existing land use map. And this is the wetlands map of a little bit of wetlands on the site. This is the aerial photo of the site. And this is the public hearing notice sign posted on Lillian. This is looking onto the subject property. It's a little dark, but this is another picture of the subject property. This is looking east on the eastern boundary of the property. And this is another view of looking down the driveway for the property. This is looking west to the subdivision Lillian Woods. Just another view of the residential neighbor. This is looking across Lillian from the subject property. Looking east on Lillian. And this is looking west from the subject property. This is looking southeast at the adjacent property on Lillian Highway. And this is another angle of the adjacent property that's the HCLI next door. And this is another parcel with the commercial zoning next to that car wash. And that's all the maps and photography.
Okay. Board members, any questions about the maps and photography? All right, hearing none, we will ask Ms. Bush to come forward. Chair recognizes Ms. Bush as an attorney. And if you would just please state your name and address for the record.
Good morning, Honorable Board. Meredith Bush, 125 East Intendencia Street, Pensacola, 32503.
All right, good morning. Do you understand that you have the burden of providing substantial competent evidence that the proposed rezoning is consistent with the comp plan, furthers the goals, objectives, and policies of that plan, is not in conflict with the Land Development Code?
Yes.
Okay. Did you also receive a copy of the staff's findings of fact hearing package?
Yes.
Okay. Please proceed.
Good morning. If you would go to page 11 of our submittal. I'm just going to walk through the application and the 5 criteria. You may recall this was previously submitted at the last meeting with a request to go to HCLI, at which time we withdrew and asked to delay for further negotiation and conversation with planning staff. After doing that, we've determined and believe we have staff support to go to LDMU as a transitional category. As to criterion A, Staff finds, and we agree that the proposed amendment is consistent with the intent of the comprehensive plan and the future land use category of MUS. The utility infrastructure is readily available. The proposed development will utilize the existing roads, utilities, and infrastructure that currently serve the parcel. The parcel will be used for business operations and indoor material storage, and are compatible with the listed range of allowable uses within the MUS FLU. As to criterion B, the proposed amendment to LDMU is consistent with the intent and purpose of the Land Development Code. The parcel is adjacent to HCLI to the east and directly across the street from HCLI to the north. The parcel is adjacent to LDR to the west and MDR to the south. It's fenced and well buffered. Many parcels along the Lillian Highway corridor are commercial in nature. Part of our submission includes a compatibility analysis to address locational criteria, and we'd be asking that you adopt our entire submittal as your findings. The Planning Board and the BCC have the right to waive locational criteria upon reviewing the compatibility analysis as submitted by the applicant. In furtherance of that documented compatibility, there are two things I would point out. One is that there are existing conservation easements between the subject parcel and the adjacent residential neighborhood. Additionally, the applicant has been willing to record deed restrictions and has provided those to county staff, which Horace approved this morning. So it's not yet been recorded, but that is something that they're willing to do to prohibit any future industrial development on the site if someone were to come in and later try to rezone to a higher category than the LDMU, given the LDR zoning that's adjacent. As to criterion C, compatible with surroundings, the proposed amendment is compatible with the surrounding existing uses. The proposed use can be conducted and operated in a manner that is compatible with adjacent properties and other properties in the immediate area. Within a 500-foot radius, the applicant identified properties within zoning districts HCLI, MDR, LDR, and within 1,000 feet there's HDMU. There are a number of parcels with varied uses to include automobile repair, a car wash, utilities, professional buildings, a store, and single-family residences. I'd also point out that the single-family residences across the street are zoned HCLI, a much more intense category, while they're used residentially. If you look at the zoning itself, it's a commercial zoning category. As to criterion D, the amendment, if granted, would be appropriate as spot zoning, given that it's transitional in nature. The Land Development Code does not prohibit spot zoning. In this case, where the zoning would establish, arguably, or reinforce a condition of spot zoning, the isolated district is still appropriate because it would nevertheless be transitional in character between the adjoining districts. The property is situated between HCLI zoning and LDR zoning. It is directly across the highway from HCLI zoning to the north of MDR zoning. So given that the surrounding zoning and existing HCLI spot zone parcel, LDMU is an appropriate transitional category, and I believe we have staff support on that. And then as to criterion E, appropriate with changed or changing conditions, based on the existing uses and intensities and the zoning district allowances, the proposed amendment would not create urban sprawl and would be compatible with existing development. It is in the public interest to allow LDMU zoning to create a transitional zone between the LDR and HCLI properties. In staff's findings, I believe that they note that the area has not changed. I would agree to the extent that this area is commercial and mixed in nature, so a mixed category is appropriate. And I believe it's been that way for quite some time. I don't know necessarily if there's new commercial businesses, as these have existed for a while, but this would still be appropriate with the surrounding mix of commercial and residential uses. And the proposed rezoning would contribute to a logical and orderly development pattern. So those are our responses to the 5 criteria, and we would ask that you adopt our findings and our complete package to include the compatibility analysis, which addresses locational criteria.
Okay. Questions?
Happy to take questions.
Mr.
Chair, does that require a motion?
To accept her package?
Yes.
If you're offering it as evidence into the case, okay.
I would.
Chair will entertain a motion to accept the presentation into evidence.
So moved.
Okay. Second. Any further discussion? All those in favor say aye.
Aye.
Aye. Okay, Meredith, before you sit down, I'd like to explore a question with Horace about the deed restriction. And I understand what a deed restriction does. What I want to understand better is how does it track with future changes to the property? For instance, if the property were to come back for a rezoning in the future, up or down, how would that deed restriction come into play? What is the standard with the county for that?
I believe the language, I believe there's some language, again, this is not a conditional rezoning. It's basically to help satisfy the locational criteria.
Okay.
It's not conditioning upon, it's for the purpose of trying to meet and satisfy the locational criteria. And, because that ACLI allows for much more intense use, which may be more,
Horace, make
strange
sure your microphone
Yes.
is on, yeah.
Thank you. Again, I'm sorry for that. Thank you. Again, this is basically in support of the compatibility analysis in meeting the location criteria. There's language, and I'm going to read it verbatim. It says, the restricted property shall be subject to any more intensive uses other than those authorized within the low density mixed use as provided in section 3-2.6 of the Escambia County Land Development Code in effect as of January the 4th, 2022. So if we can add some language if necessary, or any legislative rezonings that may occur, we can add that language if that's necessary. But at this point, it is contingent upon the Land Development Code in effect as of January the 4th, 2022. And that's the way we can get to try to compromise in meeting the location and supporting the compatibility analysis for the locational criteria.
And to your question, Chair, if the property in the future were to be rezoned to a lower category or something, the zoning would govern over the
Absolutely.
deed restriction. The zoning is still going to govern. However, if someone were to come in and try to upzone to a higher category, then that deed restriction is going to be triggered. It would kind of be pointless to do so because that deed restriction is going to cap that development on the site to this low-density mixed use as a compatible within, to protect the residential that's adjacent, so.
Okay,
And that deed restriction goes no matter who buys it in the future forever?
Forever, it would run with the land.
Okay.
This stays with the land.
okay. All right, any additional questions before we hear the staff's presentation? All right, Allison? Just introduce your name again for this case.
Allison Lindsay, Urban Planner Development Services. Okay, this is the rezoning case requesting from LDR to LDMU. So consistent with the comprehensive plan, the proposed amendment is consistent with the intent and purpose of the future land use category of mixed-use suburban, which allows a range of uses, including but not limited to residential, retail sales and service, office, recreation, public and civic, and limited agricultural. The increase in the intensity of uses is not compatible with most of the residential uses in the area. Criteria B, consistent with the zoning. The proposed amendment is consistent with the intent and purpose of the Land Development Code. LDMU district is appropriate for a complementary mix of low-density residential uses and compatible non-residential uses. The applicant proposes to use the 7.71 plus or minus acre parcel for a commercial business and construct an accessory structure for indoor storage that may not exceed the size of the principal structure as per LDC 4-7.35B. The site is accessed from Lillian Highway, which is an arterial road, and the parcel is zoned LDR, and the adjacent parcel to the east is zoned HCLI. So the LDMU would make a transition in nature and be more appropriate than any other high zoning district. So the parcel doesn't meet the locational criteria as stated in the 3-211 because it must be within a quarter mile or a half a mile from an intersection with an arterial road. The parcel is approximately over a half a mile from the intersection of Dog Track Road as well as from Bower Road. The applicant has provided the restrictive deed, and that the parcel cannot be used for more intense uses, as discussed by the applicant. Compatible with surrounding uses. The proposed amendment is compatible with the surrounding uses along Lillian Highway. Within the 500-foot radius area, there were properties that were zoned LDR, HCLI, and the parcels to the north side of Lillian Highway are zoned HCLI. However, that's a Crown Point residential subdivision, while the adjacent parcels to the west and south of the subject parcel are part of the Little Creek subdivision. They're zoned LDR. LDMU, for the mixed use, would allow neighborhood scale retail for an increase in density more than the existing LDR. However, the request would allow a diversity in the area that currently has residential and low-impact commercial uses along that portion of Lillian Highway. Criterion D, spot zoning. The requested zoning would be considered spot zoning as there is no other LDMU in the area, but it may not have any adverse impacts in the adjoining residential neighborhood because it is still it's low density residential, but it's a mixed use. Appropriate change conditions. The land use or development conditions within the area, they have not changed, and the permitted uses of the LDMU district would allow for a mix of uses because right now there are single family, there's retail sales or retail services. So the mixed use would be appropriate for the area. And that's the end of staff's findings.
Okay. Allison, or Rachel, could you bring up the maps again, please, kind of the rezoning and future land use and all of that? Let's just take a look at those.
And yes, there is MDR on the south. I didn't mention that in my findings.
And so that HCLI that's directly next to it, what, is that a developed parcel?
That's that car wash.
The car wash?
Yes,
okay.
sir. And the HCLI zoning across the street, that was there prior to the subdivision coming in.
And just to add to that point, I know we made reference to that, but I just want to be clear for the record. We do have, unfortunately. Horace. Yes, put my mic on. Unfortunately, we do have other subdivisions with a commercial zoning category, because at the time, with the Land Development Code, Mr. Brisky was here, we had a cumulative type of zoning, and people wanted to keep the density, which is 25 dwelling units per acre. That's why they kept, because the old code allows for, it was cumulative, it allows for subdivision. But the zoning, yes, it is there, but that is a subdivision. It was only did, not because of the zoning category, but only to capture the density that was allowed cumulative at the time of the old land development code that was in place.
And also the future land use of that HCLI area is mixed-use suburban, so it does match with the current future land use.
So
they could have their residential across the street because it's mixed-use suburban versus the future land use that would be commercial, which wouldn't be allowed unless they change the future land use.
okay, so that strip going east on the map along the highway there, it just kind of seems like an arbitrary line drawn there.
No, it wasn't. Again, back in the old land development code, prior to mine being here, they had a lot of those strip type of zoning properties. It was residential, and besides that, Lillian Highway is it's a state road. They wanted to keep that commercial zoning, and we was going through the adoption of the new zoning maps. We couldn't down zone properties. So if we would have down zoned that, we made that compatible with LDR, that would have been that would have been a down zoning. So the decision was made basically to keep it as is, because not to go and down zone property. It was split back then, and to down zone all of that, it would have been problematic for the county. So we just merged it together.
And Allison, you may have said this in your presentation, but do we have a mileage mark from the property to that intersection that's to the east? And I may have missed it if you said it.
Yeah, it was more than the half a mile or the quarter mile to those two intersections.
Okay.
Mr. Speaker, this is our Gulf Beach Highway 2.0, and it's almost identical in certain areas. It's the same problem we've had every time, and unfortunately, I think it's cumbersome upon the applicant. I mean, we have HCLI, and the future land use is what? Mixed use suburban?
Mixed use suburban.
Yeah, that makes sense. But I mean, this is where it gets messy for us. And I guess I would ask if there are any speakers, because if there are any speakers.
We do have speakers on it, yes. Okay. Staff, anything else before we move into public comment?
No, sir.
And I would like to say, and that's why staff did look at everything. We tried to, because we know the area, we looked at the maps, we looked at all the criterion. That's why the code does allow for LDMU, which is a transition. We could not, because of the impact of the surrounding area, it would be hard pressed for staff to support a heavy commercial light industrial there. But the code does allow for that low density mixed use transition with that restriction, meeting that location criteria. That's why staff was able to support this with those key points in place and with those standards that we sort of can lock in at this point if the board make a recommendation for approval.
Okay, thank you. Meredith, did you want to add anything before we go into public comment?
No, I'll hear from the public.
Okay.
And so, Mr. Chairman, I did want to also say that with the LDMU zoning, the permitted uses are not as intense as the commercial or HCLI. So you can't have, your bars and nightclubs. You can have your neighborhood retail sales and services and some of your personal service shops.
And everything got to be within the confines of a building. Everything got to be with no outside. We have a broad definition of storage. No outside storage. Everything got to be must, if it's approved, got to be with confines of a building in order to have buffering to help the surrounding LDR requirements.
Okay.
For visual impacts.
All right, thank you. For those members of the public who wish to speak on this matter, please note that the planning board does not consider general statements of support or opposition. They base their decisions based on the approval conditions and exceptions described in 2-7.2 of the Escambia County Land Development Code. Please limit your testimony to those approval conditions and exceptions described in that section 2-7.2. Please also note that only those individuals who are present and give testimony today on the record at this hearing will be allowed to speak at the subsequent Board of County Commission meeting. Our first speaker is Tracy Solt. Good morning, ma'am. If you'll please be sworn in and then state your name and address for the record.
Raise your right hand. You solemnly swear affirm the testimony about to give in this case will be the truth, the whole truth, nothing but the truth, so help you God.
Yes.
Would you spell your last name?
S-O-L-T.
Thank you. Good morning. If you'll state your name and address for the record, please.
Good morning. Can you hear me okay?
Yes.
All righty. My name is Tracy Solt, S-O-L-T. I live at 11598 Aruba Drive, Pensacola.
Okay. Go ahead with your comments, ma'am.
Okay, thank you. It's the first time I've been here, so thank you. I've tried to be prepared, and I have some different pictures of the land as it exists, as it's being used now.
Okay.
I don't know if I didn't know how to share that. Can I email that to somebody? I don't know.
Kia, I mean, she's offering it as evidence in the case, so we can bring it in.
Yes, Mr. Chairman, you can just ask her questions in terms of who took the pictures, when they were taken, and you guys can make a motion as to whether to accept it.
Okay.
Okay.
And then we can get them to us.
Right, so what's the easiest way for her to get them over to you all?
How do I email it?
Okay.
You can send it to right now, you can send it to my phone. You can, if you're ready.
I got my computer.
Okay.
I'm gonna give you my email, you can send them to me,
Okay.
and then I can put them in the folder, we can open them up.
Absolutely.
ADHOLMER@myescambia.com. There you go. Thank you.
I think it should go. Thank you.
Okay. Ms. Salt, while those pictures are coming through and they're going to get them for the board to review, how many pictures do you have approximately?
There's 4, I think.
4 of them, okay. And did you take each of those pictures personally?
Yes,
Okay. On or about what time frame were the pictures taken?
about 5 days ago.
Okay. And you believe them to be true and accurate pictures of what was there at the time?
Yes, sir.
Okay. So before the board can accept them into evidence, we'll need to see what they are and understand them, but we'll consider them. So if you want to just go ahead and keep moving, we'll then bring them up as soon as they are available.
Perfect. I just want to mention, like I said, my name is Tracy Solt, and I am the president of the Manchester Homeowners Association. So I represent 167 homes, approximately 300 homeowners that live there that are also against this. So I just wanted to make that clear. And I guess I'll go through, as I understand, the approval conditions. And so the approval conditions, I assert, are not logically and orderly development for the future land use. I do not believe they are consistent with the comprehensive plan, going from 4 dwelling units per acre to being approved for 7 dwelling units per acre. I know that the pictures that we looked at earlier show some other types of use. And across the street is Crown Point, and it was mentioned that Lillian Woods was a subdivision, but that is inaccurate, I think, in the very beginning. Lillian Woods is not the residential subdivision. It's Little Creek, Manchester, Crown Point, and Heron Bayou, which are close down the road. So I just wanted to make sure that's clear. Lillian Woods is around on Lillian Drive, closer to Blue Angel Road. It's a long way off. But if you were to drive through there, there are residential areas. There are probably over 300 houses in Crown Point. There's a new subdivision that was built right next to it, a road. If you go the other way, there are new residential homes that are built in that area. There are existing, I know Evans Auto Repair, we use them, they're already there. But this, as I understand it, this land was purchased when it was the low density, which allows for 4 dwelling units per acre. It was purchased as that. And since it was purchased by this particular owner, and those are the pictures I would like to show you, they're already being used for a different use, which I think is disrespectful to the whole zoning process. It's a personal opinion, but I think that you buy something as is, it should be used as is until you can gain a change. I do not think it is consistent with right now the zoning district provisions. As it was noted, even though across the street there's a different zoning, it's Crown Point, it's about I think there's about 300 homes, and even in the back there's it's a place called the Reservation. So all around that area are, and the traffic is crazy bad already. I wish we could, I don't know if I can ask you guys to give me 4 lanes out there, but that would be, might be nicer, but I don't think this is the right place.
State road.
This is State Road. Okay, roger that. I do not think it's compatible with surrounding areas, while that right next to it, there is a car wash and there's there's already like, I think 3 places, maybe 4 places in a row. But this particular property, the entire fence line is the backyard of Little Creek subdivision. And I don't know that people are here today. When I did take a picture of the sign had fallen over. I put it back up, so y'all will see my pictures. I took a picture of the sign, I raised it back up, so I'm not sure how many people from Little Creek knew. But the subdivision I live in, you go through Little Creek, which means I'd pass this every day, and right now it looks like a junkyard. I will show you the pictures. It's kind of what it looks like. But me and everybody that I represent passes by that every day, so I do not think it's compatible with surroundings. I do not think that it's a good transitional, that's my opinion, and I know that you guys are going to make the decision, but there's already enough, and to the point this young lady made, it's more than a mile to the intersections where we have, you know, I think there's a Tom Thumb, a Greer's, a Dollar General. They're all on intersections. They're not on that straightaway. So I see that it's not appropriate to spot zoning, and I don't think it is appropriate with changing conditions, because the majority of the construction there, the new construction, has been residential. I think somebody said, this lady, can't remember her name, sorry, she said that it would be well buffered. It comes right up to everybody's backyard. That road, you can see the neighbors' fences from that road in Little Creek.
Ms. Solt, I have a couple comments
all
and
I have.
questions for you.
I'm good.
First of all, thank you for your participation in coming. Unfortunately, we can't really accept that you're representing all the people because of the quasi-judicial of the nature. They would have to be here and give testimony for us to accept it. We understand that, you know, you might be the leader of that group. My question is, where is your subdivision that you?
Okay. If you look at the map here and you go just west of the plot that's being looked at where it says an LDR, and that road right there is Little Creek, where it ends on Aruba Drive is the road that I live on. That's
Okay, so Aruba starts a new subdivision. It's not part of Little Creek. That's two different subdivisions.
Correct.
Okay. And so staff members, the mailing would have gone to all the individuals that were in this radius?
In the circle.
Yes, 96 notices were mailed out.
96, okay. So 96 individuals would have gotten the mailing. So just wanted to make sure that you understood that they, you know, in addition to the sign, there were mailings that are sent out to the people directly adjacent to it. Okay.
Can I make a comment back to that? It's really difficult for people that work to get off at 9 o'clock in the morning or 8:30. I had to take a couple hours of annual leave to be here today. I took annual leave in December as well to come here and wait for 4 hours. So I'm happy to see that this was presented today.
I understand. We're all volunteers ourselves, and we take time off from our careers to come in as well. So I can understand that. Do we have the pictures yet? That's right.
Come off of
Some are
retirement.
retired.
I've got 6 more years till I retire, so.
We're
I'm
eating into
with
his
you.
golf game right now, so.
Yeah, but I get it, and I do appreciate the fact that you're volunteers. I've been a volunteer for city government in Mississippi before I moved over here, so I get that. But some people can't afford to take off. And I'm happy that and grateful that you guys can. Okay. So, yeah, you can just go straight to the pictures. That's the sign that I put back up. It was laid over on the side.
Okay, so the board is going to consider all of your pictures as one attachment for your evidence. And so as we go through them, just explain what they are, that you took them, and approximately when you took them, and then we'll vote to bring them in as evidence.
Roger that, thank you. Okay, next slide. So this is a picture from the street, and it shows that there's just a whole bunch of stuff out there. And currently, it is zoned for low-density residential, and it's being used for something other than that. Next slide. And this is still this is just what the property looks like, and you couldn't see it from the other pictures. And this is other pictures of the property. Still, and that right there was out next to the street for sale, and there were people stopping and looking at that. So anyway, next slide. And the other ones are just the areas that I was going to address. I just didn't have time to put a nice slideshow together. So those are the only pictures that I have.
Okay. Chair will entertain a motion to accept, what is it, I'm sorry.
Sorry, y'all were discussing the photos only?
Yes.
Not the additional text
Yes.
slides? I just wanted to make sure we.
Yes.
Yeah, the additional text slides, all they are A through E, the approval conditions, so I'm fine to remove those. That's all. I was just going to speak to each of them.
Okay,
Thank
so we're considering the pictures only as evidence. Chair will entertain a motion to accept, what is there, 5 pictures? 5 pictures into evidence, and we'll.
So moved.
Motion,
Second.
we have second. All those in favor say aye. 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 And we'll label those SOLT Exhibit 1. So we have record of those 5 pictures being all part of the same exhibit. Okay.
Thank you.
A couple of questions. Horace, you were very adamant, I think, about explaining that everything would be indoors if this zoning.
Yes, sir. Yes, sir. And I think Ms. Crawford, Ms. Bush, she want to address that as well.
Okay. Ms. Solt, if you would just have a seat over on the side, we'll let Ms. Crawford come back up, and we'll give you an opportunity to complete your statement in just a moment. Go ahead, ma'am.
Thank you. To that question, in LDMU, everything would have to be inside. There's also no outdoor storage, and that's the purpose behind this request. The applicant wishes to construct 2 large, within the code's allowances, buildings in which to put all of the boats and trailers and different equipment that he has stored on the property inside. This all stemmed from a code enforcement action because it is low-density residential, and there is equipment on the site being stored outdoors right now, but before he could construct the necessary structures to house the equipment. So to Ms. Salt's comment that the site looks like a junkyard, all of that would be moved to the interior of the building. LDMU doesn't allow for boat repair or anything like that, so it wouldn't be people bringing and dropping off boats to be fixed. The applicant operates Seatow, a commercial boating type industry, but would be using this site only for indoor storage of his extra equipment. As to the notification, for the December meeting, we sent personal letters to everyone within the 500-foot radius advising of what was happening, that we were asking for HCLI, and engaging the community. There were 2 phone calls received back, and at the end of those conversations, both of the individuals were fine with what Mr. Ward or WMS wished to do with the property. So I don't know whether or not Ms. Salt's address is within that radius. We used what the county had provided as the notification, but we also sent, in addition to the sign being posted and the county's postcards, everyone received a letter saying, hey, here's our contact number, here's what we intend to do. And I believe it's a little over half a mile. I don't think it's quite a mile to those intersections. But she is correct as to the 7 dwelling units per acre. I mean, at this stage, there's no intent to increase the residential density of the area. The intent is to use it for indoor storage. However, as you all know, any of the allowable uses would need to be compatible and we'd proffer that we've shown that they are compatible.
Okay, thank you.
And I would like to add to that as well. Thank you, Ms. Bush. Again, staff looked at this considerably when it first came in, and it was going to be, staff would not have supported it at all for ACLI because we know the area and we have the concerns of the neighborhood. With the understanding that even if the planning board do approve and the BCC approve, there must be some buffering requirements because during our site plan review process, because it is adjacent to LDR, those buffering standards are very, very intense. And if they need to push some more, we're gonna definitely push for some more. Fencing, wood fencing, that is critical because that LDR. So the buffer, they may have to plant some trees, those things within the confines of the building. No outside storage. If things cannot go there because it is a code enforcement action, they're gonna have to be removed, point blank. Point blank. So staff is definitely concerned, and we do believe that the owner, along with Ms. Bush, that they are considerable, but it's still your decision. But any of those other stuff that cannot to fit within the buildings, because you cannot have, we got a very, very broad definition of outdoor storage, very broad. It got to be removed because LDMU does not allow for any outdoor storage as defined by our land development code. If this is approved, if the planning board make a recommendation, and if it's moved to the BCC for their approval.
Okay, thank you.
Question, so Horace, what you're saying is that LDR, the requirements or the rules are much broader than LDMU, is that correct?
Well,
Because that has been the state of the property for some time, and I know that prop's been out there for quite a long time, and I'm just curious if that, apparently from Ms. Bush, that's the impetus for why they're asking for the zoning change.
well, it is my understanding, Mr. Powell, that it was LDR, that there was a code enforcement action brought upon it, that there was a code enforcement, and code enforcement got involved. It's been a long-standing code enforcement issue. So therefore, they're trying to modify and adhere to the land development code requirements, because LDR does not allow for those uses, and that's why code enforcement got involved. So they're trying to make it whole. They're trying to get a path for compliance with all of the regulations of the land development code.
Go ahead, Mr.
I got a
Simmons.
couple of questions, and as always, I prove the rule. There really are stupid questions. My first question is, in terms of timing, when does the deed get approved? And how does that relate to the actions by development services, which may or may not allow the building that would accommodate their needs?
Oh, we're gonna, to answer your first question backwards, if this get approved by the board, with your recommendation, the site plan review process gonna automatically kick in, and there will be a time limitation because they're still gonna be under this action to satisfy, so they're gonna have to move expeditiously.
Yeah, because what I thought I heard was once the deed goes into effect, it can't be changed.
Right, so we're currently on a clock for the code enforcement compliance. They've been through a first round of DRC quite a while back, which addressed some of the wetlands and stuff, but the deed, now that we have an agreement that what we proposed is sufficient for the county's purposes, it would be recorded immediately. I mean, I intended to do it today. And that's kind of separate from and would govern, regardless of what you gentlemen do, but it wouldn't allow for this use unless you approve. So your zoning of LDR, if you were to deny, would still stand. That deed restriction is not going to change the fact that they're bound by that LDR zoning. However, if you approve, and then the Board of County Commissioners on Thursday approves the LDMU, then the deed restriction would just prevent any future action on the property. As far as the site plan goes, we've engaged an engineer who has attended several meetings with us and the county, and they're ready to go. They simply can't construct the buildings to put all the stuff indoors in the LDR zoning. So the LDR zoning is what needs to be changed so that these structures can be put up and all the stuff that the neighbor is complaining about can go inside and will no longer appear. The property on the outside won't appear as it does now. It would just simply, you would see two buildings.
Yeah,
and then there's a
I guess what I
residence
was hearing is that the requirements are liable to be fairly strict, and it might become either a financial challenge or a logistical challenge or something else that might not make it attractive to the owner. And then you're faced with a similar situation. Where you've got a
And
piece-
we're under code order right now. So the burden on the owner is for us to come into compliance, and this is the path to comply with that.
Okay,
Right.
and for
Mr.
Horns, tell me again why this isn't a variance situation where they go to the Board of Adjustment?
Because the variance does not allow, variance only deal with hardships on the land that they need to, for this type of use. LDR does not allow what they are doing, so they would need a rezoning.
Okay.
And that's what they are here for. And also too, Mr. Simons, your question I never stupid, it's good to ask them, because it helps us to think as well. We will have to make sure, because if, during our meetings, I was point blank, that we need some more. We need more to help solidify the location criteria. So that's what we came to this resolution, but it's still up to you all to decision. But we tried to work with them because we know they're in the code enforcement action. We know the impact of the neighborhood.
Okay.
We know the area.
One correction, apparently this is going to the BCC in February, not on Thursday, so, okay.
Okay. Mr. Adams?
Yeah, I just want to play a little devil's advocate here, but what is the increase in residential units with this, that could be put there with this new land development code?
7 dwelling units versus the current 4,
And this is the thing.
but they're not gonna do residential
Okay, so if
development.
there was a change in their thought process, okay, heck, we're not gonna go through this, it's gonna be too much money, we're
Yes,
gonna
sir.
go ahead and pile some houses in there,
And I can
so
tell
it
you
would
right
come
now,
back to this board?
I can tell you, no, they would not. If the zoning is approved, they would not have to come back before this board. They go straight through the site plan process.
That's right.
But I've been doing subdivisions long enough. This area is so constrained, the size, what you have to do for a subdivision in this lot,
It's not feasible.
it's not feasible.
But they would have the choice of not coming back before this board if they wanted to go to residential units.
It would go to DRC.
It'll go straight to my other department, the site plan process. So a subdivision in that, the lot is too constrained. Subdivisions are very, very hard and expensive to do and very, very cumbersome with the regulations.
Okay.
So,
Go ahead, Reed.
I guess my question is, how long has, the owner has owned this land for a while, how long has it been out of compliance as a business running CETO with equipment out in the yard?
And let me say something too. I do know that it's been a long time, not length of time, because remember, even in 2019 we had COVID, so therefore it slowed everything down with all our meetings. So Jeff, I don't want us to think that it's grandfathered, because it's not grandfathered in.
No,
It's
and-
not a grandfathered in. It's just been COVID sort of slowed things down.
And we're not arguing that it's grandfathered in or that the use of the property with the
Meredith.
outdoor store.
Microphone, please.
Oh, sorry. We're not arguing that it's grandfathered or that the use of the property with outdoor storage, or the use of the property commercially is permitted in low-density residential. But the applicant or an owner of CETO is present and can answer questions regarding how long he's owned the property, There was an individual living in the residence, which arguably, could have been a home-based business exception. However, that person no longer lives at the residence, so now it's strictly being used for this outdoor or storage of equipment, which we're trying to remedy.
Ms. Bush, do you wish to enter the gentleman as a witness in the case, or is he going to be coming in as a public speaker?
He could come in as a witness as the applicant.
Okay, if you'll go ahead and introduce him, we'll have him sworn in.
This is Mr. John Ward. He's the owner of the property.
Okay. Sir, if you'll be sworn in and then state your name and address for the record.
Raise your right hand. Do you solemnly swear or affirm the testimony about to give in this case will be true, the truth, so help you God?
Yes, sir.
All right, thanks, sir. Please state your name and address for the record again.
Good morning. My name's John Ward, 13726 River Road, Pensacola.
Okay.
32507.
Meredith, are you going to ask questions, or do you just want him to give a statement for the record, or how do you want to proceed?
I was going to have him respond to Mr. Rushing's question. John, if you could tell the board when you acquired the
Come
property.
closer to the microphone. Sorry, I keep reminding y'all, but this is all being broadcast and recorded, so it's got to go in the microphone, so.
I apologize. I was going to have him answer Mr. Rushing's question. So, John, if you would, just advise the board when you purchased the property and how long you've been operating CETO at that property.
I believe I purchased the property at an auction. I want to say it was either 2013 or 2015. I'm speaking by memory, so I don't know exactly the date. And just for clarification for the board, I don't operate CETO out of the property. CETO is ran at my office at 13726 River Road. They're underneath the Theo Bars Bridge next to the Oyster Bar. That is the office. This specific site was purchased, and it was misrepresented at auction as to the land use and zoning, which is a different issue, and I get it. But it was purchased strictly as a laydown yard for my equipment, because the equipment is just stored there. The excess equipment is just stored there. And for years I stored equipment there, and there was never an issue. I didn't even know, what the zoning rule was. I grew up out there on Highway 98, everything along that corridor. There's only 3 residential houses that are actually on Highway 98 from Bower Road to Dog Track Road. But nevertheless, evidence-wise, it was just nothing. It's not a run. CETO isn't run out of this location. It's nothing but a laydown yard. And for years, I had one of my employees rent the house there. He worked there, and he also rented the house. And so there was one of my employees living there at the time. Then I had a disgruntled employee, and it turned into a code enforcement violation. So that's how we got here. My plan for the property is to do nothing but do that, to store my excess equipment. If I got to build 2 buildings to store the equipment in, that's what I intend to do. But to do that, I got to get this zoning redone.
So is it the intention to knock down the residential home that's there now?
No, sir. My plan is to try to build the buildings around that existing house.
Any other questions for the gentleman? All right, Meredith, any other staff you wish to cross-examine or ask any questions? Okay, thank you, sir. Okay, this time, Ms. Solt, I'm going to let you come back up and briefly give a closing statement to your comments. I would ask you, and I'm not trying to change your opinion of this, but were you aware of all of these things that have been brought forth into evidence, such as that all of this would be contained indoors, that there'd be buffering requirements, and that there's a deed restriction that's being proposed? Did you have all that info before you came in today?
I did not. It's really difficult to find information ahead of time.
Okay.
And I get it, and I appreciate the homeowner. I work in, I work in business, and I get what it takes. And unfortunately, it sounds like he bought the property as an LDR, but didn't know it was an LDR. And like he said, that's a different issue. But the issue is, it was, and since 2015, maybe they've 6 years, non-complying, I equate that to buying in a subdivision in a homeowner association and not wanting to comply with the rules and regulations just because you don't want to, because you thought it was different. Those rules were in place when you moved in. So I just wanted to make that, and I think you asked a question about what would the change be. So as I understand, there's 7 acres there, and right now it's 4 dwelling units per acre per low-dense LDR, which would allow 28 houses to be built in there. If it were changed, it would allow 49 houses to be built in there. So I just wanted to make sure that you had that question. And like I said, while I do appreciate it, I do not think that it complies with the approval conditions, and it's not logically or orderly development for future land use. And so that's it.
Okay. Thank you. Yes, sir, you have a question?
I wanted to also state, Mr. Adams, I think you're right on. We are supposed to think about what could be there. But given that, and so I just wanted to encourage, I think he was on the right track with that. I also understand Horace and the logic, even though the math says 4 per acre or 7 per acre, I would agree it'd be highly unlikely if anybody could do a subdivision. But that being said, you know, I think that and Horace, correct me if I'm wrong, that the property owner, by having the gentleman living there, was, without his knowledge, still in compliance because it was basically a home-based business. Is that accurate for LDR? Or is that supposed to be LDMU?
No, let me put it this way. I'm trying to remember. The Land Development Code did allow for a home-based business. However, everything had to be within the confines of a building.
Okay.
Yes, sir, within the confines of a building. I love office that you're working and you're going somewhere else.
Right. So, okay, either way, so if it was in compliance, it has definitely, you would acknowledge it's been that way for a long time. And, I mean, with the prop out there, I mean, I've driven, I live in that side of town, I'm there all the time. It's been that way for quite some time. I mean, we also acknowledge adjacent right next door is heavy commercial, or HCLI. You have a car wash. Would it not be an improvement if the owner were to build a building and house all that storage? Would that not be, I would think, more attractive to the homeowners in Little John and or Aruba?
Well, I hear what you're saying, and that may be these homeowners and what they decide to do, but as to y'all's point, the future use would allow, I mean, you could put an apartment complex in there. I mean, there's a whole bunch of things you could do with it, so I hear what you're saying, and he does seem like he's would be a good tenant or owner of that. But I also wanted to make a point. While I heard him say that there's only 3 houses on the road between there and Bauer, but what he failed to say is all the homes from is at Crown Point are on that road. They don't face it, but there's more than 3. So I don't want it to sound like there's only 3. There's a subdivision on the left, there's a subdivision on the right. But there might be only 3 homes that actually have a driveway to it. There will be more than 3 homes that are along that corridor. I guess I just want to say thank you for listening to me and hearing my concerns.
All right, thank you, ma'am.
Ma'am, I would just kind of reply that I agree with you. It is a mess. I live off Gulf Beach. I've been in here on the other side of it trying to do this, and it didn't work. But I mean, it's a mess, and we are the fortunate folks who have to try to figure it out between what was and what should be and what will be. And along there, you've got every possible use along that. Like I said, it's very similar to Gulf Beach Highway. Pick your side of Gulf Beach Highway, it doesn't matter. But, and I appreciate you coming and articulating your thoughts. And it's hard, not only the timing, but also you're the first person who's come, quite frankly, that I recall in recent memory that adhered directly to the criteria. I appreciate it. That's all. It's just it's a tough spot to be in.
Thank you for your time.
Thank you.
All right. Mr. Ward, I know you've been called forward as a witness. You have signed up. Did you wish to speak in public comment as well? Or All right, sir, you still are under oath. Please state your name and address for the record for this portion.
John Ward, 13726 River Road, Pensacola, Florida, 32507. I just would like to make comment to her as far as what kind of neighbor I would be. I'd go on record to say, and I've mentioned this to Horace and my attorney, there is a very thick buffering that goes along that privacy fence that goes back through Little Creek, and then where Little Creek comes to the north or south of the property across the back. And I don't intend to mess that buffering up at all. And I'll let it grow, you know, I ain't gonna trim it. So there's a fence, and there's a very, very thick brush buffering that's just gonna get thicker. It obviously took a pretty good impact from the storm for Hurricane Sally, but I have no intentions of trimming any of that, and you know, try to be a good neighbor. The letters we sent out that Meredith mentioned, I got 2 phone calls from those letters. No other response, no written response. I got 2 phone calls from 2 neighbors, one from across the street, Crown Point, and one from the subdivision to the south behind me. And once I answered the questions, both of those clients were fine with what my intentions are. So I live out there. It's my home. I grew up just right across the street down the road. So I have no intentions but to be just a good neighbor. That's it.
Thank you, sir. Meredith, did you have any closing statements you wanted to make?
I would only just direct your attention back to the 5 criteria and submit that we've met those 5 and ask that you approve our request or recommend
Thank you.
approval.
Allison, anything else on behalf of the staff? No, sir. Okay. All right, Chair will entertain a motion. Please keep in mind that the staff's findings differ from what was presented by the applicant. So we do have to, if you make a motion to approve, you would have to accept those alternate findings as substantial competent evidence to fulfill those criteria. If you want to offer to deny, then you could rely on the staff's findings of incompatibility. So Chair will entertain a motion.
I think staff did, Allison, please. I think staff is in support of this LDMU. So please state that again, Allison.
Yes, sir, because in all my findings, I said it either was consistent or the only thing that was different would be considered spot zoning, but it was compatible with the surrounding uses. It is consistent with the LDC, and the area hadn't changed, so.
Okay, I misunderstood then. I think that by accepting the deed and the locational criteria was the main issue that you were looking at, and with the deed restriction on it, you feel like that satisfies that requirement?
Yes, along with compatibility analysis as presented. Yes, sir.
Okay. All right. I am corrected. You can rely on the staff's findings for compatibility if you so wish. Chair will entertain a motion.
I'll make a motion to approve as staff findings.
All right. Thank you, sir. Do we have a second?
I second it.
Seconded. Do we have further discussion? All those in favor say aye. Aye. Opposed?
No.
Okay. 3 in favor, 1 opposition, so the motion passes. It'll be recommended to the Board of County Commissioners for approval. Ms. Salt, you'll have an opportunity to go and speak in front of the commissioners at that meeting. So, all right. Thank you. Good luck with it. That's our only 2 cases for today. Do we have any other items that we need to cover in rezoning hearing? All right. Hearing none, we are hereby adjourned. Thank you, Dave. And I will immediately call to order our regular planning board meeting. For this meeting, did we have proof of publication?
Yes, sir.
Okay, and did that meet all of the legal requirements?
Yes, sir.
Okay, we do have a quorum. We still have 4 members and a ex officio non-voting member. Chair will entertain a motion to waive the reading of the legal for this meeting.
So moved.
Motion, do we have a second? Second. All those in favor say aye. All right, you've previously been provided the meeting minutes for the last meeting. Are there any additions, deletions, or corrections? Hearing none, Chair will entertain a motion to accept as is.
So moved.
Motion,
Second.
second. All those in favor say aye. Aye. All right, Planning Board hearing package for today, January 4th. Previously been provided to board members. Chair will entertain a motion to accept that hearing package and the legal advertisement into evidence.
So moved.
Motion, do we have a second? Second on the motion, yes. All right, all those in favor say aye. And opposed? All right, motion carries. Okay. We have our first public hearing, a public hearing concerning the review of an ordinance amending Chapter 4, Section 47.3, that the board review and recommend to the Board of County Commissioners for adoption an ordinance amending the Land Development Code, Chapter 4, Section 4-7.3, accessory uses and structures to identify conditions for home-based businesses as permitted accessory uses to dwellings consistent with House Bill 403, which was enacted in 2021. Drew, are you presenting? All right, good morning, sir. If you'll
Good
state your
morning.
name and position for the record.
Andrew Holmer, Development Services Department, Division Manager.
Thank you, sir.
Bit of housekeeping, two things from the earlier meeting. One, Mr. Salmons, the variances are for dimensional requirements, distance, height, things like that. Can't get a variance to uses. Uses are specific within the zoning. Mr. Adams was here. Oh, okay. I'll tell him when he gets back.
Yeah, you can.
I got an
tell
answer on that sidewalk thing, on why some of those projects don't have them.
Okay.
Yeah, we need to, I'm glad. We
And
need
I'll-
to correct that for the record.
I'll explain
Okay.
when he gets, yeah.
When he comes back in, I think he's still here. It looks
Yeah.
like he just went maybe to the
Okay.
restroom.
Okay, so House Bill 403. This was passed this last year. This is another situation in which the state of Florida has said, listen, throughout the jurisdictions, some are more strict than others, or more restrictive than others regarding home-based businesses. So the state said, listen, we're gonna set down our rules. We're gonna preempt you on this, and essentially keeping, allowing people to have home-based businesses with some restrictions, but trying to keep in the performance standards that would protect the character of the neighborhood, essentially. And I'll go ahead.
Go ahead and finish this one up, and then we
Okay.
can come back to that.
So, in the past, in fact, in our previous land development code, it even limited the square footage that could be used for a business within a dwelling. As of right now, it has other restrictions, including if you're going to have employees there, that's conditional use through the Board of Adjustment, just to have non-resident employees come to to work there. Another point of contention that's been constant with this, current regulations do not allow customers to come to the house. So our front counter folks deal with this with certain licenses through the ATF. ATF requires customers to come to the house, and our code wouldn't allow that. So it's been a contentious issue over the years, but this proposed change, based on the legislation, would resolve that. So, y'all ready for me to kind of bring up the
Yep.
strike through underline?
Yep.
Okay, let's go
And,
through that.
thank you, Drew. And I got a question. I thought about it this morning, Kia. Okay, being that this is it's a state law, basically. If we did not do, I want to be clear, if we did not do it, if someone came and said, I want to go by the new rules that are in place that was approved by the state, and our old regulations have not been changed. What do we go by?
So even if we did not put this new language into our code, this language of the state statute still controls. So we're allowed to be more stringent than what the state requires, but we cannot be less lenient. So we do need to go ahead and put this into our code for clarity's sake so that people do not get confused when they read our land development code and see the old language.
Okay, makes sense. Drew, turn your mic on.
Sorry. So what we've got on the screen now, this is the current language, of course, done in our strike-through underline formatting. The current rules, which again have changed from the previous LDC, but still are different than what the state is bringing forward. If you'll go down to the next page. Okay. So here we have the changes. This is what was written in respect to the changes proposed from the state. Do you want me to go through it line by line or just give you a summary on each one?
I guess the only question I would have is this language from the state, or is this your interpretation of the state's language?
So it's a combination. It's the state's language plus some changes that were made to fit in with our local formatting and the current local rules without going beyond what the state said.
So mostly just formatting, the A may be, an A versus a 1 or something like that.
Yeah.
Okay.
To try to fit, well, yes. I can't tell you every single exact change in. I wasn't the one who did it, but that's the basic idea, is we have to format it to fit in with our code.
But this is, words-wise, this is the state's words.
It brings the state's words into our code that way.
Drew, I have
yes, sir.
kind of a technical question. I remember this coming up once before in this very section, but let's say an individual has wants to do a home-based business, and they may have customers visit their business at their home. In the past, I think it was a requirement of the county that you would have to retrofit the building, like add ADA bathrooms and parking and ramps and all that stuff. Is that still in place, or does this kind of override that?
Not in the land development code, and not in any of these proposed changes. It doesn't go into those requirements. It does mention, if we go down to, if you go down to G, which deals with appearance, it does mention on line 40, any external modifications made to a dwelling to accommodate a home-based business must conform to the residential character and architectural aesthetics of the neighborhood. To me, that says ramps, if you need to bring in a ramp. The ADA requirements are through the building code as opposed to the LDC. That's the portion that I think would address that.
But you wouldn't necessarily be required to retrofit your home with all of those things if you were going to allow a customer to come in.
That's what I said. That's not part of the LDC. That's
Okay.
through the building code on the other side of the house.
Okay. I know and I'll just say, one of my neighbors wanted to do a dog boarding business because they have a large piece of property and they figured, okay, people go on vacation, I'll watch their dogs for them. Well, when they started getting into it, they found out you can't just let people come and bring the dogs to you because it's a business, and you'd have to put in parking and ramps and all that kind of stuff. So
That hit them when they tried to come through development review for change of use, because that's a full-on DRC project there. These are limited to a home-based occupation. The person lives there. the primary use is as their dwelling, and this is just an accessory to it,
I see.
a smaller scale, so to speak.
Okay.
I have a question, Andrew, based on what you just said. It's the primary residence. Does that tie into, do they have to homestead?
It's the primary use as a residence. Let me see if I can find that. 7A, there we go, sorry, thank you. Line 3 on
Right.
that next page.
So I guess my question on that, is that your
Oh, yeah.
terminology or is that the state's terminology?
That's through the states.
So it's secondary to the,
It says, "The activities of the home-based business are secondary to the property's residential use. More specifically, the business is an accessory use to the principal residential use of the dwelling, not a conversion of the dwelling or a change of its use." It doesn't mention that it had to be a homestead. Someone renting a home could still have a home-based
This
occupation.
has to be residential use.
yeah,
Correct.
I'm curious for obvious reasons. You know, if somebody bought a house that were in a residential place and simply did not sleep overnight on that location, however used it as a home-based business.
That would bring them through DRC, because then you're gonna have a change of use if it's not a residential use.
Because they're not sleeping there.
Correct. This home-based occupation is just accessory to that principal use of residence.
Mr. Chair.
Yes, sir.
So I'm trying to get this straight in my mind. So a hair salon, do they want to,
So,
would that
yeah,
would
You
work for
could
this
have-
situation? I
correct.
mean,
But you would also have, so we also address in here off-site impacts, signage, parking, how much parking you would have, and making sure, essentially, all these standards through the state and through us is in keeping that you're allowed to have this home-based occupation, but because it's an accessory to the principal use of a residence, you're not out there transforming it in a way that it doesn't fit in with the neighborhood. You still got to protect the residential character of the
so if you're going
area.
to do haircuts, you'd have to do it in one of the rooms of the residence and no changes.
Correct. We used,
Ordinance, okay.
like I had said before, our old code even had a limitation on the amount of square footage you could use for the business within the house. This, we no longer have that requirement, and this removes that requirement from, well, everybody in the state now, not just us. Okay, so going through, keeps language about licenses and taxes have to be dealt with. The off-site impacts, we regulate that, noise, heat, glare, dust, that sort of thing. It has to comply with any regulations, county regulations regarding that. Signage, okay. If y'all remember, we changed the signage regulation based on the Supreme Court that it's content neutral. If you're allowed to put up a sign there, whatever square footage, whatever's on that sign is beyond our control. So technically, someone could put up a sign in their neighborhood for their business at their house. Employee residency. So the employees of the business who work at the dwelling need to reside in the dwelling, except that they can have 2 employees who can come that don't have to reside there. And if it's, let's say it's, you got a business there that you're dispatching employees. So if they're working in a remote area, that's fine too. You're just dispatching from that location. Parking. It says the need for parking generated by the business, including non-resident employees, may not be greater in volume, which is quantity and size of spaces, than would normally be expected at a similar dwelling where no business is conducted. Essentially, if you go through the neighborhood and there's room for 2 parking spaces, they need to kind of fit in with that character. Vehicles and trailers used in connection with the business must be parked in legal parking spaces that are not located within the right-of-way, so they can't be in the street, on or over a sidewalk or on any unimproved surfaces at the property of the dwelling. You gotta have some sort of hard surface for that. Appearance, the use of the residential property needs to be consistent with lawfully established and maintained uses of the residential areas surrounding it. And the external modifications, which would need to be made, need to fit in with the character. You know, somebody could put, if they need to put a handicap accessible ramp in their front, they're still gonna have to do it whether there's a business there or not, if they need that. Let's see, the home-based business shall not conduct on-site retail transactions at a structure other than the dwelling. However, incidental business uses and activities may be conducted at the property of the dwelling. What this is saying is you're not gonna build an accessory, a shed, and have your business run out of the shed. It's gotta be run out of the house. If you had a shed and you wanted to put some stock in there, you could do that. Hazardous materials, once again, it's got to meet all those requirements that we have locally, or state or federal even. County regulations for that cannot be more stringent than we would for any other residence. All right, prevailing conditions. Now, this is where there are still some restrictive type of regulations under these conditions. Condominiums, obviously, you've got that form of ownership is going to have certain agreements. Same with cooperatives, HOAs, lease and rental agreements, and Mr. Lemos is here to talk about Santa Rosa Island. You know, if you're renting a house and the lease you signed said you can't have business out of it, sorry, you still can't have the business. Transient public lodging. Okay. If you'll recall, for short-term rentals, the state preempts us on that as well. We get those phone calls all the time. Why can't we stop it? But we're not allowed to. That's the basic overview of it.
Okay. Any questions, board members? Okay. No, we don't have anyone signed up. Is there anyone from the public here? I don't think we have anyone from the public here.
I move to approve it.
Yes, that's right. All right, if there's no questions, is there anything else to present?
No, and I'll go finish up the other explanation afterwards.
I move we approve it.
All right, that's what I was waiting for.
Second.
Motion to approve and a second. All those in favor say aye. Aye. Opposed? All right, motion carries.
And Mr. Adams, I wanted to tell you, I got more information on the issue of sidewalks. It is a 2-mile radius from the front door, but the part of the issue here along 9 Mile, that's state road. Sidewalks in the right-of-way there are up to the state, not us. Even though we want that, yes, sir. I was gonna say that would explain it.
And also too, and I would like to add that that's why I stated to be reviewed at the site plan review by our subject matter expert, because the requirement explicitly says for the interest of a subdivision. Now, a commercial project may not be required to have sidewalks, to put in sidewalks, unless it's connecting to another sidewalk. So that's why I want to be clear. That's why I said my subject matter person, the sidewalks can be very, very cantankerous and get very, very contentious. So as Drew stated, the regulations are there. We got to go by those regulations, and because it says at the interest of a subdivision. So if the new subdivision, Mr. Jason Walters here look at that and make sure that it complies with the regulations.
That sounds like a good conversation with Representative Salzman. on the state road and see. Or some type of impact fees
Exactly,
to pay for
that's-
that requirement.
State's jurisdiction.
All right, very good. Do we have any action, discussion, info items today? Nothing? Okay.
I have my own agenda item, thank you, Horace. Thank you. I have my own agenda.
We about to go to that, Horace. Anyone here for public forum? No. Horace, your chance on the spotlight. Directors for review.
I want to say thank you, board members, for an outstanding year last year. We looking forward to continue to work with each of you in your endeavors as the planning board members. We are grateful to have Mr. Kevin Adams here representing, taking the place of Miss Patty Hightower. She was excellent. She was an historian, always knowledgeable in many aspects. So we appreciate her length of service that she provided to the Escambia County Planning Board members, and we are expecting bigger and better with Mr. Adams. Thank you for
And I want to say I appreciate Board Member Hightower. She is now working on the Children's Trust. So we decided it was good to kind of move around these committees to take a little pressure off her. So she did a wonderful job on this board. Appreciate it.
That's right. Well, I echo those statements. Ms. Hightower was always a big help to me as she was very strong in understanding Robert's Rules of Orders and would help me sometimes when we had some difficult decisions to make. So we're going to miss that strength in the board. All right, at this point, we are going to have a county attorney's report.
Can I ask a question?
Yes, sir.
And this may not be a problem for y'all. Y'all may be fine doing what you're doing, but just a thought. I know that the requirements and all that we do in these judicial hearings have to be covered every time. But I'm kind of curious, would it be more helpful if we somehow pre-recorded them and played them? Would that make it easier on the chair and the vice chair?
what you mean pre-record them.
Reading the
Introductory
criteria,
statements.
his
Gosh, I would love
his
that.
opening statements, his, what do you call it, your,
Monologue?
yes.
It's long.
You know, I mean,
But
I guess as long as it's read in the record, it,
I would allow that too. By the legal counsel, I want rezoning process is so.
I would prefer that it continue to be read into the record. We could just have a form that's put up on the screen, but then in the event that the form was not added to the packet, then it would not be part of the record. So that would be the best bet, is to keep reading it in.
gotcha. It's very wordy. I
Yes, it
stumble in it all the time, and I've read it 100 times, but I still stumble reading it.
So if it was his voice and it was recorded, that could not be done that way? He'll be sitting right there and we could make a motion accept, just to save him a little time.
I
he
do
can make
have
one
to, I
recording.
do have to say, today, as far as my memory, the one, Ms. Salt who spoke, it's the first time I've had somebody prepared to speak to, ever. And as much as you say it, put it down.
Ever.
So I know that we become numb to it, and your reading, no offense, or my reading, I don't care who it is, it's monotonous, but I don't know if that had any impact on anybody out there speaking, whether it was pre-recorded or that. I don't know if they would shut it off. She may have remembered it from the last time, because I do believe she did sit here for 4 hours, or at least that was it was a longer afternoon, but
I think
whatever we need to do to reinforce it.
I think citizens would be more likely to kind of zone out if it was a recording that was just playing in the room and we were all sitting here listening to it.
Of course, unless we got Morgan Freeman to be the voice, or somebody like that, now, you know, I mean.
And I agree, yeah, because we do have people that watches us, and I can tell you right now, you'll be surprised, I receive emails during the hearings from people, I'm not saying who, if things is not going right. And that's why, I walk out, I have to call them, so if there's a small technicality, especially in the rezoning process, it gets in legal hands, it really does, so.
This will go back to my comment that I was going to hold to the end, but we're talking about the sounds and, such. If we had Horace doing the speaking, because, and he's got two voices. He's got the voice way out here that nobody can hear.
Or he's got the voice of God when he's talking to you. And this would be a great one to hear all of those with. I think it would get across to everybody.
Mr. Reed, I owe you.
All right, Kia, I think you still have the floor, so go ahead and finish
Yes.
if you would.
Thank you. So this is my last county attorney report. This is my last planning board meeting. I don't need your commentary, Horace. I'm leaving the county at the end of this month. I will be joining the Clark Partington firm. I have enjoyed my time with you guys over the past few years. I wish you all the best, and you guys are in excellent hands with Mr. Shad.
Thank you. Well, Kia, thank you so much. You've kept me on track many times and given us great advice, so we really appreciate it. And you'll be missed, but hey, opportunity awaits. You got to jump sometimes. So wish you all the luck in the world. And I have a feeling we'll see you back here someday. Even if you say you're not going to be doing what Meredith does, you'll be back here for something. So, okay. Anyone else have any additional things for the meeting? All right. Well, we'll look forward to Mr. Shad being welcomed in at the next meeting. And our next meeting is, give me the date here, February 1st here in this meeting. Do we know how many cases we have so far?
Potentially 2 large scale, 2 small scales, and 2 rezonings.
Okay. So it'll be a 3 or 4 hour. All right. Well, please again respond to Rachel about attendance, because as you could see today, one of us could have messed the whole meeting up if we didn't show up. So we got to have that quorum. And I appreciate you helping me get my county email reset, so it's working now. So anybody else having trouble with that county email? I'm sorry. We probably don't say this enough, but be very cautious about using any of your personal emails, because then they become discoverable as far as sunshine rules, as far as if you're communicating with people with your personal email. So I try to keep anything to do with this on that email, so it's pretty important. So other than that, if there's nothing else, we are adjourned.
Yay.
And Horace, we need our clock fixed. It's about 20 minutes off. Well, 15.
It breaks again.
You think the county